3401AL. We've got petitioner, Ms. Witkowski, and attorney, Mr. Bauer. Who's appearing on behalf of the respondent, Secretary?
Jeremiah Buffalo working on behalf of the Secretary.
All right, Mr. Bauer, I have had a chance to review the pleadings in this matter and the record and your brief. Go ahead with the argument.
Well, Judge, I know you've had some familiarity with these appeals yourself in private practice and what petitioner has to go through to try to get her driver's license.
Don't see too many with 20 years plus of abstinence.
Amen. And say a serious relapse history. She has a serious sobriety history, Judge. 23 years. She proved by clear and convincing evidence, hands down, that her alcohol problems are under control.
When's the last time she used heroin?
Yeah.
When's the last time she used meth?
Exactly.
When's the last time she used mushrooms?
Yeah.
But those weren't problems.
No, exactly.
Is that the only reason for the denial?
He quoted a serious relapse history, Judge, which was the only reason for the denial. But that seemed to fly in the face of reason in that after 23 years, she hasn't had a relapse.
Well, let's see what the Secretary has to say, and you can reserve some rebuttal.
Absolutely.
All right, Mr. Virgo.
Your Honor, as noted by the ALJ, there is a subsection in Administrative Rule 257313. Though the ALJ quotes subparagraph F, I do believe he meant to quote subparagraph D, being that the hearing officer may require that the petitioner present evidence from not less than 3 independent sources to corroborate the petitioner's behavior with respect to alcohol and controlled substances. As such, Your Honor, this is a requirement that is allowed by the administrative rules, and the ALJ was supported by clear and convincing evidence in this decision. Thank you.
Thank you. Any rebuttal?
Again, Judge, I think this was a stretch by the hearing officer. I don't know why they would deny. And the other one, judges, we've only requested the interlock device as well. We don't, was it full driving privileges? We can monitor for another year with the interlock. So I think it was an arbitrary, capricious use of his discretion.
Well, in this case, the petitioner had 4 convictions for drinking and driving. The last one was in 2002, 23 years ago. The evidence that petitioner presented was that she'd been sober since that time. And the hearing officer made a finding to that effect, saying, quote, Ms. Witkowski's claim of abstinence from alcohol since August 2002 was supported by her evidence. The hearing officer nonetheless denied her petition for license restoration because she failed to document that she has also abstained from drugs. However, there was 0 evidence that drugs were ever an issue for this petitioner. Therefore, I believe that's an abuse of discretion. The evidence available showed that she had never used marijuana or other drugs, except a brief prescription for Percocet while she was receiving medical treatment in the past. The substance use assessment and the drug screen showed no problem with drugs. So as I read this over, this appeared pretty clearly to be an example of a hearing officer looking for any technical reason to deny the petition, rather than objectively and dispassionately assessing the evidence to see whether the petitioner had proven by clear and convincing evidence that her substance abuse was under control and was likely to remain under control. Her 23 years of abstinence does that. There was a recent opinion as well saying that even the imposition of a restricted license with the interlock has to have some evidentiary basis. I see none on this record. I grant the petition in full and would sign an order directing the Secretary of State to restore full driving privileges to Mr. Witkowski.
Thank you, Your Honor.
I've been presented with a proposed order. So I've signed both parts of the first copy, and the other ones can be true for you.
Thank you, Your Honor.
If experience tells me anything, the Secretary of State will want to see a prosecutor's signature on that as approval as to form as well.
Absolutely.
So if you want to review that, Mr. Woodrow.
Thank you.
Up to me. Mr. Bauer, you had another appeal?
I do, Judge.
Mr. Clark, wants to call that case up?
We're ready.
This is Dwayne Clark v. Secretary of State, file 25-3402 AL. We have Mr. Clark, the petitioner, and his counsel, Mr. Bauer, present in the courtroom. Who's appearing on behalf of the Secretary?
Jeremiah Buffalo Worgo on behalf of the Secretary.
All right, Mr. Bauer, go ahead with any arguments, sir.
Yeah, Judge, this is an appeal after a revocation on a misuse of the interlock device. My client was on vacation or traveling to Florida, had a positive flow, I guess, or a test, an alcohol reading, and instead of properly following the procedure and blowing in it again, he panicked and had his girlfriend drive his vehicle. He's had 10 years plus of sobriety, had no violations, no issues up until that one, I guess, panicking episode. And he ultimately did blow in the machine later and was zeros. But the abuse of discretion here, I believe, is that they've revoked him entirely. They didn't reinstate his interlock. They just revoked him. He's not able to drive again or petition for another his driving privilege for the interlock to be reinstated until May of 2026. So normally in our past practices, Judge, I mean, we see 2 or 3 different violations and then a revocation, not just one and done. And so I believe it was an abuse of discretion based on just this one panic violation that he had. He could have reinstated him and he could have been eligible. We could have monitored him further. And then, so we're asking, that obviously the court to reinstate those restricted driving privileges.
Thank you, Mr. Workman.
Your Honor, in this particular instance, appellant petitioner had a short leash. His license was revoked because he drank and drove. Maybe he did have sobriety for 10 years up until March 9th, in which case, Your Honor, he went on vacation, he drank, he sat in the driver's seat, blew dirty, and then had his girlfriend go ahead and blow and drive. The hearing officer absolutely had the discretion to revoke the license based on that, Your Honor. I think beyond clear and convincing evidence that Mr. Clark poses a danger to everybody and he will likely reoffend again. Thank you.
Thank you, Mr. Bauer. Any rebuttal?
And Judge, I appreciate the prosecutor's position on that. This was an early morning. He was on vacation. I think the blowing dirty, I think it was that anything can set that off, judges, and well, not anything, but monster drinks, double cheeseburgers from McDonald's, pizza, certain mouthwashes, or even cough syrup for that matter. But what he did was fail to blow in it again. He was not, the violations, I think, register anything at a 0.025. And if he were just to blow into that again, follow the directions. What he was guilty of was not following the procedure and giving another sentence.
All right, well, in this case, when there's a Secretary of State action for a violation of the interlock, the petitioner had to prove by preponderance of the evidence that the reinstated revocation, which, man, that's a weird way the law says it, that should be set aside and modified. Here, the hearing officer declined to do so for several reasons. The violation was 0.029 BAC reading in the interlock device, and then a second one at the same. And then Mr. Clark did not follow the instructions to continue to provide samples until it zeros. Rather, he allowed his girlfriend to drive and to blow the zeros. Mr. Clark argues now that he shouldn't lose his license revoked again because of technical failing to follow the rules. I have sometimes been persuaded by a similar argument where it's truly just a technical rule violation, but here there's a little bit more indication than that. The hearing officer set forth what those were, that Mr. Clark was on vacation, that these were the first blows in the morning, so that said, quote, Mr. Clark input 2 failed test samples in less than 1 minute. These were the first breath samples of that day, and the burden of proof is squarely on him to prove that this was not a reflection of alcohol use the evening before in a hotel room while he's vacationing to Florida. He did not provide any additional breath samples in 2 hours later. That would render that 0 BAC reading meaningless because of the metabolism rate. And he also failed to obtain an independent test to demonstrate that he had no alcohol in his bloodstream. Under those circumstances, it's awfully hard for me to find that there was a lack of evidentiary support for the hearing officer's decision or that it was an abuse of discretion. The standard here today is not whether I would have reached the same decision, although on this record, I may very well have. I do think that it is not an abuse of discretion. So therefore, the appeal in this matter will be denied, the Secretary of State's decision be affirmed, and somebody can be in order that. All right, this is file 25-93374FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo, work on behalf of the people.
Good morning, Your Honor. Christopher Parks on behalf of Lawrence Goddard, who sits to my right.
All right, good morning. We're here for a docket call. What's our status in this matter?
Your Honor, we've reached a plea agreement in this matter. I've gone over advice rights to my client. He signed it this morning, as well as the plea offer, and I would submit it to the court this morning.
Okay, if you want, Mr. Bailey. Okay, Mr. Goddard, would you please stand and raise your right hand for me, sir? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Be seated. All right, Mr. Goddard, the guilty plea hearing is an important event. It includes the waiver of rights that you have, so please listen carefully. If you have a question, ask me. If you need a minute to talk to your lawyer, you just say so. I have to advise you the maximum penalty that you could face. We're offering to plead guilty to counts 1 and 8. And that is, count 1 is possession of a firearm by a prohibited person. It's a felony punishable by a maximum of 5 years in prison and or a $5,000 fine and mandatory forfeiture of the weapon. Count 8, domestic violence, is a misdemeanor punishable by 93 days and or a $500 fine. Do you understand the maximum penalty? Yes. Are you on probation or parole in that?
No.
Are you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights form?
Yes.
And you signed that?
Yes.
Do you have any questions for me or Mr. Parks about any of those rights?
No.
Do you understand if you plead guilty, you give up all those rights and won't have a trial?
Yes.
And is that what you wish to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by threats to you or promises not put on the record today. Do you understand that? Also, when you plead guilty, you lose the right to appeal. If you want to appeal, you have to seek permission by an application, and the types of issues you could raise would be very limited. Do you understand that?
Yes.
The agreement provides in exchange for your pleas to counts 1 and 8. There's a dismissal of the other charges, and it says no habitual enhancement. There was none that has been filed as of this date, but the prosecutor would be able to file one up through today's date. So they're saying that they won't do so. And the plea was contingent on waiver of the prelim and entry of the plea today. So there was a time deadline for it as well. Do you understand the terms of that plea agreement?
Yes.
Mr. Parks, is that a full, fair, and accurate statement of the terms?
That is, Your Honor.
Mr. Wargo?
It is.
Mr. Goddard, other than that plea agreement, has anybody promised you anything to get you to plead guilty today?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead the charge in count 8, possession of firearm by a prohibited person? How do you wish to plead the charge in, I'm sorry, I said count 8, I meant count 1. How do you wish to plead to the charge in count 8, domestic violence?
Guilty.
So, Mr. Goddard, back on March 10th of this year, were you in Prescott County?
Yes.
And were you with Miss Goddard, your spouse?
Yes.
Okay, did you and she have some kind of argument?
Yes.
And did you, during that argument, place your hands on her or make some physical contact with her?
Yes.
Did she give you permission to do that?
No.
And would that contact have been harmful or offensive to her?
Yes.
And also, on that date and time, were you in possession of a firearm?
Yes.
Did you have a previous conviction for purchasing pseudoephedrine for illegal purposes, a
Yes.
felony? And did that previous felony conviction render you legally ineligible to own or possess that firearm?
Yes.
Okay, and you knew that?
Yes.
Right. Mr. Parks, are you satisfied with that factual basis?
Satisfied, Your Honor.
Mr. Virgo?
I am.
Mr. Parks, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Virgo?
None.
And Mr. Parks, in your judgment, has the court fully complied with the requirements of MCR 6.302?
You have, Your Honor.
Mr. Virgo?
The court has.
All right, Mr. Goddard, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis, in fact, and law to believe you guilty of those offenses. So I hereby accept your plea and schedule sentencing for December 1st.
Your Honor, I'm actually in a jury trial in Alpena on December 1st. Can we have a date in January, please?
Any objection to that, Mr. Virgo?
None.
Okay,
I do apologize, Your Honor.
that's no problem. We'll set it for January 5th at 9:30 a.m.
Works, Your Honor. Thank you.
And Mr. Virgo, any objection to continuation of bond?
The people would object, Your Honor.
Okay, want to make any argument about that?
Yes, Your Honor. Defendant is now guilty of possession of a firearm and domestic violence. He hit his wife, brought gasoline jugs into the house, threatened to burn her alive, put a round-in battery with the hammer back on a lever-action rifle and pointed it at his wife, threatening to kill her. There is no more clear danger to our community. Thank you.
Mr. Parks, any response?
Yes, Your Honor. He's had no contact with the victim since March of this year. Has had no issues on bond since he's been on bond, Your Honor. And those are issues that prosecutors can raise when it comes to sentencing. However, Your Honor, I believe for terms of bond, disingenuous considering he's had no issues since he's been out on bond. I would ask that you continue his bond at this point, Your Honor.
All right, well, at this point, the defendant is no longer cloaked with the presumption of innocence, and bond is entirely discretionary of the court. I see that there are some mandatory prison charges that were dismissed as a result of the plea agreement. But it does sound like it's a serious event that would certainly carry at least a couple months of jail from me for a sentence. So Mr. Goddard can start earning credit now. His bond is hereby revoked. He's removed into the care and custody of the Prescott County Sheriff.
You want me to?
Yeah, I need to go to the truck.